Lady Rose will explain the judgment of the court.
One of the challenges that the legal community has grappled with for many years has been how to ensure that people who have been injured in a road traffic accident are not deterred from claiming compensation by the fear of legal costs. In road traffic claims where the injuries are not serious, the compensation may be several £1,000s, but it doesn't take long for the legal costs incurred by the potential claimant and the potential defendant to mount up. The worry on the part of the claimant is that they might lose the case, and then they will be liable to pay not only their own solicitor's costs, but also the costs of the other driver's defence of the claim. Different solutions have been put in place over the years, particularly after legal aid for such claims was abolished. The aim is to strike a fair balance between ensuring that on the one hand, an injured person should not be put off by legal costs from obtaining compensation, whilst on the other hand, protecting defendants from being pursued by claims that have no merit because there is no possible downside for the claimant in having a go. The current rules of court found in Part 44 of the Civil Procedure Rules are the most recent attempt to strike that balance. The scheme, which applies to almost all personal injury claims, not just to road traffic accident, is known as a QOCS scheme, that's QOCS. That stands for Qualified One-Way Cost Shifting. One-way cost shifting means that under the rules, if the claimant wins their case, they can claim their legal costs from the defendant in addition to their damages. But because cost shifting is only one way, if the defendant wins the case, the defendant cannot generally claim their costs from the losing claimant. They have to bear those costs themselves. The one-way cost shifting is qualified, however, because the defendant can recover some of their costs in some circumstances, but only up to a certain limit. The particular circumstances that arose in this appeal raised the question of how far the rules do allow the defendant to recover their costs, in particular where the claimant has been successful overall in getting compensation for their injuries from the defendant, but where during the course of the claim something happened which resulted in the claimant being ordered to pay some costs to the defendant. The present dispute arose in this way. Miss Adelekun was injured in a road traffic accident on the 26th of June 2012. She alleged that Miss Ho, the other driver, was liable. After some initial correspondence between their solicitors, Miss Ho offered to pay Miss Adelekun £30,000 to settle her claim and also to pay Miss Adelekun's legal costs up to that point. Miss Adelekun accepted that offer and a settlement agreement was concluded between them for the payment of that money. However, there was then a separate dispute about how much of Miss Adelekun's pre-settlement costs Miss Ho should have to pay. That assessment dispute had to go to court and in fact was appealed up to the Court of Appeal. The Court of Appeal held that Miss Ho was right. She was only liable to pay Miss Adelekun £16,700 towards her pre-settlement costs of pursuing the personal injury claim, and not the much larger sum that Miss Adelekun had wanted. In other words, the Court of Appeal held that on this point Miss Ho was right. As usually happens in court proceedings, the person who loses has to pay the costs of the winner. So the Court of Appeal ordered Miss Adelekun to pay Miss Ho's costs of the court hearings that had been needed to resolve the assessment dispute. The position at the end of the case was, therefore, that Miss Ho was liable to pay Miss Adelekun the £30,000 in damages for her injuries under the settlement agreement, plus £16,700 towards her pre-settlement costs. But Miss Adelekun had been ordered to pay Miss Ho her costs of fighting the assessment dispute, and those were said to be about £48,600, and she had a court order that Miss Adelekun had to pay her that amount. But having a court order is not the end of the story, because the QOCS rules govern how far that costs order can be enforced by Miss Ho against Miss Adelekun. So what do the rules say about whether Miss Ho actually has to pay Miss Adelekun anything, given that they have ended up owing each other roughly the same amount? The answer depends on a careful analysis of the wording used in the rules that apply. The rules say that a defendant can enforce a costs order they have obtained against a claimant, but only to the extent of the aggregate amount in money terms of the costs orders do not exceed the aggregate amount in money terms of any orders for damages and interest made in favour of the claimant. One might think that that meant that Miss Ho could at least enforce her costs order against Miss Adelekun up to £30,000. But in an earlier case in 2018 called Cartwright and Venduct Engineering, it was decided that where the damages are paid to the claimant under a settlement agreement without there being a court order for damages, then those damages do not count towards the aggregate that the rule says you must not exceed. Miss Ho therefore has to accept that because of the judgment in Cartwright, she has to pay Miss Adelekun the £30,000 in damages, and she cannot refuse to pay that on the basis that Miss Adelekun has been ordered to pay her costs of £48,600. In fact, therefore, the aggregate amount in money terms of any orders for damages and interest made in favour of Miss Adelekun is zero. Miss Adelekun argues that according to the wording of the rule, the result is that Miss Ho cannot enforce the costs order at all and must still pay Miss Adelekun the £16,700 she agreed to pay by way of pre-settlement costs. Miss Ho argued that that couldn't be right. She argued that she can at least set off that £16,700 against the £48,600 she is owed before she starts to consider whether she can enforce the remaining net costs against Miss Adelekun. The Court of Appeal in the judgment under appeal held that Miss Ho could set off the costs she is owed by Miss Adelekun against the costs she has to pay. In the judgment handed down today, the Supreme Court unanimously allows Miss Adelekun's appeal. We have decided that there can be no set-off by Miss Ho of costs against costs under Rule 44 in this case. The effect of the rule as currently drafted, bearing in mind that earlier decision in Cartwright, is that Miss Ho has to pay Miss Adelekun the pre-settlement costs and damages she agreed to pay her, and she cannot enforce the costs order that the Court of Appeal ordered Miss Adelekun to pay her at all. Miss Ho argued before us that she can set off the costs against each other because that doesn't count as a kind of enforcement of the costs order prohibited by the rule. It is only the net amount of costs owed to the defendant that is subject to the restrictions on enforcement. The Court has rejected that argument. We consider that Rule 44 works as a monetary cap on the amount that a defendant can recover in costs, rather than specifying the way in which the costs can be enforced. The effect of this cap is to require the defendant to keep a running account in money terms of all cost recoveries which it makes against a claimant, and to cease enforcement when the cap is reached. Since, as I've said, the aggregate amount in money terms of all court orders of damages and interest in Miss Adelekun's favour is zero, that prevents Miss Ho from enforcing her order against Miss Adelekun. The Court recognises in the judgment that this conclusion may lead to results that at first blush look counterintuitive or even unfair. Different policy arguments were put to us by the parties as to why this result would undermine or support the overall policy of the QOCS regime. We hold, however, that it is the result that follows from the true construction of the wording used in the rule. The wording of the rule, and indeed the whole QOCS regime, has emerged from detailed discussions between the insurers of drivers who represent defendants and the specialist solicitors who act for claimants in the many thousands of these kinds of disputes that are dealt with each year.